So we're going to kick off. I'm going to pass you over to Damin, who is going to be presenting the webinar today. So how it's going to work is Damin is going to present on a few common areas that we've been getting and questions in relation to what is happening with this global pandemic. Once Damin has gone through his presentation, we're going to open it up for questions as well. So make sure as you're coming through, you'll be able to see on the left-hand side, there's a place where you can ask a question. I'm going to be showing these questions to Damin throughout so that when we have the time at the end, he'll be going through those questions. So make sure that you're getting those questions in. And without any further ado, I'll pass you over to Damin.
Good afternoon, everybody. I hope everybody's safe and at home or in an office that's safe. Certainly, we're having some trying times. If you watched Morrison's video yesterday or his announcement yesterday, it obviously brings everything forward, and it's obviously just difficult times. So my name is Damin Murdock. I'm a principal at Murdock Chang Legal Practice. I've been part of the Lawpath network for many, many years, and we primarily work in general commercial, consumer business, litigation, IP law. We have several offices. We have an office in Sydney. We have an office in Melbourne. We have an office in Surrey Hills as well, Sydney. And today we are presenting on several different issues. Primarily today is going to be on employment law related issues, but we will touch upon commercial leases as well. We'll talk about the updates of the Corporations Act, and we will discuss the initiatives from the government. And today you'll learn a little bit about what you can do with your employees. Under no circumstances am I suggesting you should lay off any staff. This presentation is really about knowing your rights as an employer, what you can and cannot do, and how you implement certain things such as forced annual leave, forced shutdown, paying out your annual leave, what you do about your commercial lease, and so on. So before we start, we are going to answer all your questions, hopefully, from what I know, but we will try to answer those separately at the end during the question time. And Tom will work with me in going through those questions. So if we look at leave entitlements for employees, oftentimes you need to decide or determine whether your employee is on a modern award. For those who don't know what a modern award is, it's the minimum employment standards for specific industries. So for instance, if you're in the hospitality industry, you have the Hospitality Industry General Award 2010. If you're in the construction industry, you have an award for construction workers. If you're in retail, you have one for retail. If you have any office managers or receptionists, they might fall under the clerical award. And so what you need to determine is, does your employee fall under a modern award? And if it does, then the modern awards gives you guidance regarding your close down and regarding payment of annual leave. But the first thing is before you do close down your office or pay out annual leave or force unpaid leave or make someone redundant or something along those lines, all modern awards have a consultation requirement. And those consultation requirements are normally in clause 8. And to give you an example, if you have a look at the Hospitality Industry General Award, it says, if an employer makes a definite decision to make major changes in production program, organization, structure, or technology that are likely to have effect on the employees, they must give notice to all employees of that change. They must discuss with those employees those changes. They must introduce those changes and specify what the likely effect will have on the employee, and put in measures that are going to have the minimum adverse effect to employees. So what this means is if you intend to make a major change, such as forcing people to work from home, making them take unpaid leave, making them take their annual leave, closing your physical office. Those are all a change, and the modern award will come into play. Even if you don't have an employee on a modern award, the modern awards give good guidance to employers who have employees who are not on a modern award, because it spells out exactly what the good governance is and good steps to take. And so when you look at that section 8 of a modern award, you need to consider following those steps. If you're on a modern award, you have to follow those steps. If your employee's not on a modern award, you should still follow those steps. And that means issuing a letter to your staff, talking about the changes, talking to your staff about what changes are going to be made and how that affects them, and put in some measures to reduce the adverse effects to them. The second thing is looking at section 32 of a modern award. I will talk obviously about situations where an employee is not on a modern award, but it's important for me to lay these out because they are good steps for everybody to take. Now, under most modern awards, section 34 spells out close down. If you look at the legal industry, we have the legal shutdown period. It's normally from around the 22nd of December, or the last working day of the week prior to Christmas. And then it's normally up until the second Monday of January. Same thing for the construction industry. As a law firm, as a construction company, you're allowed to force employees to take their annual leave during that period of time, because that's an industry shutdown period, and that's permitted. And if you have a look at section 34 of most modern awards, it says that an employer may require an employee to take annual leave by giving at least 4 weeks notice as part of the close down of its operations. The next section also says that an employer and employee may agree in writing to take a period of annual leave if the employee has accrued annual entitlements. And the employer and employee must reach an agreement on how much annual leave they're going to take, what the terms are, when they have to give notice, when they have to come back, and so on. There's another provision talking about cashing out of annual leave. And cashing out of annual leave is essentially that. You might want to still have an employee employed, but you might want to just pay them upfront a lump sum so they have funds to deal with what they're dealing with right now. And if you have something in writing that's agreed to, that is permitted. And that is laid out in section 34.6 of the Hospitality Award, if you want some guidance on that. There's also a section that deals with excessive accrued leave. Some modern awards talk about 8 weeks, some modern awards talk about 10 weeks. And in those situations where an employee has, let's say, 8 or 10 weeks accrued annual leave, then you can force an employee to take their annual leave. And they also have a section that deals with situations where you are not under a modern award. And that's where we go to section 94.5 of the Fair Work Act. If you have employees that don't fall under a modern award, as I said, you can look at those modern awards as guidance, even if they don't apply to your staff, just to see what good practice is. But if your employee does not have a modern award, then you want to have a look at the employment contract. What does the employment contract say? There might be provisions in there that deals with forced annual leave. There might be provisions in there for suspension of works. There might be provisions in there for closing down the office. But if it doesn't, which under many circumstances it won't, then section 34.5 of the Fair Work Act says that an employer who has employees free from a modern award or enterprise agreement may agree with an employee to cash out a particular amount of their annual leave And then it also has another section that says that an employer may require an employee to take a period of annual leave, but only if the requirement is reasonable. Now, reasonable is a legalese word. What is reasonable means you got to look at all the circumstances. And certainly COVID-19 is reasonable. So it's then looking at, well, you need to take reasonable steps. So the closing down or the forced annual leave, that will be reasonable under these current circumstances, but how you implement it also needs to be reasonable. And again, you want to talk to your staff, you want to tell them what the options are, and you want to tell them what your intentions are as well. Now, in the current climate, my recommendation would be you really have about 4 different options. Option 1, you can close your physical office and have people work at home as normal. Option 2, you can force your staff to take unpaid leave, but give them the option to either be made redundant or take unpaid leave. They have 2 options. And those options are in a situation where your employees cannot work from home. It is not possible to work from home. And therefore, you can give them essentially the ultimatum. And you can say, we don't have a choice. You either take unpaid leave and stay on the payroll and you'll continue to accrue annual leave while you're on unpaid leave. Or option 2, we will make you redundant. And that sometimes might be the better option for an employee because they might be able to benefit from government grants and unemployment benefits. The other option, obviously, is allowing them to take annual leave. And if you allow them to take annual leave, then again, you want to work that out with them. Now I've just pressed the wrong button. One moment. Tom, can you see those slides again?
Yep.
Sorry, I just have a technical issue.
There we are. 1 second, everybody. Just having a bit of a technical glitch. There we go. And what slide are you up to? Back. Oh, no. No, it's on. Let me check. Just go to the slide. Keep going. That's fine.
All right. Now let's talk about what happens if you make the decision, or you and your employee make a decision that they're going to be made redundant. If you do it by way of an agreement, that's fine, and you won't have any risk of a potential unfair dismissal claim. But let's talk about unfair dismissal claims. Let's talk about situations where your employee may actually have COVID-19. Now, if your employee has COVID-19, they might not be suitable to work. They might not be able to work from home. They might not be able to work at all. And they could be in a hospital for an extended period of time. The law says that you cannot terminate an employee as a result of sickness simply because they're sick. Not only is it an unlawful termination, it is also potentially an unfair dismissal as well. And your employee must be absent for work for a period of 3 months over 12 months. And that's section 352 and 3.01 of the regulations. So simply because someone's sick and cannot come to work or cannot perform work, that does not mean that you now have grounds to terminate their employment. and you have to wait out that 3-month period, which means that they would accrue their sick leave. They would then use their long service leave. They would then be on unpaid leave or workers' compensation, and then you would then consider whether you need to terminate their employment, and you'd probably want to get some legal advice on that. Now let's talk about working from home. Lawpath has a very good working from home policy that everybody can download for free. I highly recommend everybody installs or implements one. If you have a look at the Lawpath policy, it's very formal, and a lot of employers might feel that it's inappropriate for their office. They might be a tech company. They might not be as formal as what this policy represents. But the reality is that this policy deals with all the legal issues. And that's because when you have people working from home, you still have an obligation to provide a safe working environment. You need to make sure that their chairs are appropriate, their computers are appropriate, their workstations set up right, they're safe at work, they have electricity, they have everything that they need to work from home. And the working from home policy that Lawpath has just deals with the implementation of it, the obtaining of approval of it, making sure all the steps are set out regarding OH&S and performance expectations. Simply because an employee is working from home doesn't mean that they do not have to fulfill their obligations under their employment contract. If they are not busy and they're not covering their own wage, then you need to consider what else you can give them. Whether it's preparing articles, content, templates, cleaning up your CMS, whatever it might be, there might be other work that you can give them. But what's really important is that you're tracking your staff. What are they doing on a day-to-day basis? There's many different softwares out there that track employee time. One's called Workflow Max. It's free. It's an add-on to Xero, and it's a very basic service, but it's free for up to 10 people, I believe. And you can consider getting something like that just to record their time and what they're doing so that you can monitor your staff and making sure that they are still being productive. The other thing is communication. Right now, communication is so important. Communication with your supply chain, your clients, your staff. And we use Zoom conferencing and we use Slack. Both of those are very good. I'm not promoting any specific software, but what's really good is to be able to communicate with your staff without hundreds of emails going in and out of your inbox every day. Slack is a chat group that you can have with your staff. Zoom is video conferencing. And what's important is having a meeting every morning, finding out what everybody's doing, checking up on everybody most evenings, monitoring what they're doing, and making sure they're actually being productive and making money for your company. Because if they're not, and they're costing you money, then you have to look at your cash flow and prepare for the next 6 months. And I'll get into cash flow later, but hard decisions need to be made, and you need to know when those hard decisions need to be made regarding your staff. The other one is looking at privacy. You're going to have staff obtaining private, confidential information of your clients. You might be outsourcing already overseas. I am aware of a company that uses an overseas call center. That overseas call center works from a location in India. They have computers that have no USB ports. They are monitored at all times, and you cannot take any information out of that call center. However, India's just shut down their country. So 1.3 billion people are now working from home. And as a result of that, you need to make sure that if your call center or your outsourcing company is now taking information that belongs to you out of their office to their own personal computers, what measures are in place? You probably needed a confidentiality agreement, an NDA, privacy policy principles. You need to make sure that that data is not going and spreading everywhere. You also need to make sure that your staff have confidentiality agreements, and you have to make sure that the privacy of all your clients are maintained. In terms of physical activity, you should have something along those lines, making sure your staff are getting some exercise, getting out. There's nothing wrong with going outside at the moment, and making sure they have proper processes in place for dealing with critical situations. You will see now is a major issue for fraud and hoax. And you need to make sure that your company is vigilant, and you need to consider changing your passwords as well, because it's not unlikely that a lot of people are going to be hacked right now. So keep that in mind and make sure you have special rules to deal with all of this if you can. And Lawpath has a lot of free policies in their system that you can download. Now let's look at redundancies. If you've discussed with your client or with your employee that that they're to take annual leave because they can't perform their duties, or they have to take unpaid leave because they can't perform their duties, or if they don't agree to be made redundant, then you may want to consider making them redundant. It's obviously not something that I'm promoting. It's something that you need to know as an employer, and you as an employer, you need to make sure you cover yourself. Now, what's the definition of redundancy? The definition of redundancy is where you no longer require someone's job to be performed because of changes in operational requirements. Now, if you have a look at the definition of redundancy, the definition of redundancy means that not only are they no longer required to have that job performed anymore, but it's also that you have complied with your obligation under the modern awards, if you have one, and also you have to make sure it's a genuine redundancy. And a genuine redundancy means that you actually can prove with evidence that that job no longer needs to be performed. And you need to have a look as well as whether you have an opportunity to redeploy them into another role. And that includes redeployment into other associated entities of your company. So if you're a local subsidiary, they still have an obligation to seek redeployment in other offices. And even if you have a position that is much less skill and much less wage, you should be offering that to your employee before you make them redundant, and giving them an opportunity to be redeployed in another position. There are circumstances where someone might be in a role now that might not exist, but there's a new role that you need, such as maybe you have someone on doing sales, and now you need someone doing digital marketing. And maybe that salesperson has some skills to put into a digital marketing role, or maybe that salesperson now has the ability to do content that you need for your online marketing. And if there's another role that's going to pop up, then you need to offer that role to them. And if you do not, you risk the chance that they could bring an unfair dismissal claim against you, which I'll talk in a moment. Now, generally speaking, small business, being less than 15 employees, do not pay redundancy. They don't have a requirement to pay redundancy pay. Redundancy pay is in Section 119 of the Fair Work Act, and there's a table of how much you would have to pay based on the continuous years of service. On top of redundancy pay, if it's applicable, you also have to pay notice or give notice. And the amount of notice that you need to give is either going to be in your employment contract, or will be in 117 of the Fair Work Act. So that means that if you decide to make someone redundant, not only do you need to give them notice under section 117, you also would have to pay them redundancy pay in accordance with 119. So there's a double whammy there if you're not a small business. Now, even if you do have less than 15 employees, there are circumstances where you still have to pay redundancy pay. And that's if a modern award applies, and you'll have to have a look at the modern award. For instance, the Building Construction General On-Site Award has a redundancy scheme that deals with redundancy despite the fact that the employer might be a small employer. Now, I think that's enough for now on employment. I'll answer a bunch of questions afterwards, but let's get into the Australian consumer laws. Australian consumer laws, you might have heard of. It used to be the Trade Practices Act. You might have heard of misleading, deceptive conduct, things like that. That's in the Australian consumer law. It was enacted as a schedule to the Competition and Consumer Act 2010. So it's Schedule 2 of the Competition and Consumer Act, Schedule 10. So if you Google Australian consumer law, you'll find a lot of different links, but you might not actually find that act because you're much better off just typing in Schedule 2 of the Competition and Consumer Act 2010. And if you do that, then the Australian consumer law will pop up right away. Section 18 deals with misleading and deceptive conduct. Section 31 deals with misleading and deceptive conduct in relation to employment. Section 50 to 60 deal with guarantees. And that's what I'm going to talk about now, is guarantees in relation to goods and services. Now, before we look at the Australian consumer laws, you first want to look at, do you have terms and conditions? Do you have terms and conditions with your customer on your website? Do you have a written terms or a contract entered into before providing the terms? Do you have them on your invoices, on your purchase orders, on your quotations? You want to look at what those terms say before you look at the Australian consumer law. Australia consumer law is mandatory. You cannot contract out of it. There are clauses that deal with exclusion clauses. Exclusion clause says that the Australian consumer law does not apply. Exclusion clauses are unenforceable. So these guarantees apply. However, you can build processes and systems in place in your terms that deal with these awards. Or deal with these guarantees. For instance, the Australian consumer law talks about refunds. Well, you can lay out what your company refund policy is or credit policy is. So have a look at your terms. Important clauses are termination, extension of time, dispute resolution, refunds, credits, replacements, delivery. You need to consider your supply chain. And if there's going to be a delay, there might be a clause in your terms that say, if there's a delay, I'll give notice. There might be a clause that deals with extension of time. If there is no term dealing with an extension of time to deliver services or to provide refunds or credits or replacements, communication is more important than anything else. So follow the terms in your agreement. And if there are no terms in your agreement, then remember that you need to start communicating. And to communicate, you need to know what the law is. And the law is between section 51 and 64 of the Australian Consumer Law, which is Schedule 2 of the Competition and Consumer Act. There's more guarantees. I've only laid out the main ones. And the main ones are a guarantee as to the acceptable quality of the goods or services. This one's specific to goods. Is it fit for purpose, free from defects? If you're buying product from overseas and selling it now in Australia, and a lot of people are buying product and then selling it, make sure you have an agreement with the manufacturer in China, and make sure you have an agreement with whoever you're supplying it to, whether it's the end-to-end consumer or whether it's somebody else. The reason is that as an importer of goods, you are deemed the manufacturer. So if you bring goods into this country, you are now responsible for those goods. And if they're defective, the consumer can sue you, and you will then have to sue the manufacturer. Now, what's important about goods is looking into product liability insurance. Many, many years ago, I had a case where someone brought in plumbing parts from overseas, and they won a massive contract for thousands of units, building or apartment units. And all these plumbing parts were supplied into all these apartments. And while they're building these apartments, they started moving people in. And as they started moving people in, each one of these plumbing parts started to break. And everything started to flood. And it ended up being a $20 million damage claim. Now, our client had product liability insurance, but the manufacturer who manufactured them didn't. And so even though our client would have liked to have brought in the manufacturer from China, without insurance, that manufacturer will just close down. And you really want to make sure you have the insurance company covering it, not you as a company. So look into product liability insurance if you bring the things in, and remember, you're responsible. And so you also have the fit for any disclosed purpose. And right now there might be various products that aren't specifically made for a purpose, but it's being used for something else. So if you represent to someone saying, well, you can use it for that, and they use it for that and it doesn't work, then again, you'll have a problem. For instance, I acted for a very, very large manufacturer of machinery. They said, you can use this for your landfills. They used the machinery for the landfills that got filled with plastic bags. The engine broke. Our client tried to sue the person who had not cleaned the machine from the plastic bags. Their defense was, even though it's not manufactured to work in landfills, you told us we could use it in landfills. So it creates a defense for them. They have to match the description, whether it's a good on Amazon or eBay. You put up a picture, it should look like that. If it's not going to look like that, you need to have special conditions in your agreement that says if you order timber floors, they might not look exactly like the picture, for instance. And then you need to have spare parts, replaceable items, things like that. And those might be very difficult to get at this time. The next one is looking at guarantees for services. You need to do due care and skill, and you need to make sure you're putting in reasonable resources into something. If you promise to deliver something, and now because of COVID-19, you don't have the resources to actually deliver, you're going to be in breach of the contract. You're also going to be in breach of the ACL. You need to communicate and figure out what you're going to do to make sure you can deliver. And if you cannot deliver those services, you need to start putting systems in play to make sure that you can comply or at least minimize your risk to loss. Same thing as fitness for a particular purpose and performed in a reasonable period of time, whether it's a fixed date, agreed term, whatever it might be, you need to consider that. Generally speaking, in contract law, you cannot claim for consequential loss. So if you say, I promise I will deliver this website to you by the 1st of May, and they rely upon that delivery of that website by the 1st of May, and then you don't deliver by the 1st of May, and now they're losing all their sales that they would have generated from that new website, they will want to go and sue you for their lost revenue that they would have received. Generally speaking, they won't be able to, because that's what's called a consequential loss. And as a consequential loss, you're normally not entitled to recover consequential loss. But there are a lot of cases that change that law, and the Australian consumer law changes that as well. And that's in circumstances where you should have known or where they specifically told you. There's a case from England called Headley versus Baxendale, and it said something along the lines of there was a mill and it had a large shaft that broke, and they went and they said, we need this shaft to be returned to us within a month. And if you do not return that to us in a month, we're going to lose a lot of money. Can you guarantee you can deliver that back to us in a month? Otherwise, we'll find someone else. And they said, yes, we can fix it. We can get it back to you on time. They didn't. They were sued because they were told about the consequential loss in advance, and therefore they were found liable for that consequential loss. So it's important to have terms and conditions minimizing your risk regarding consequential loss, but it's also important to make sure that if someone tells you specifically that they need it by a certain time or date, that you cover yourself in terms of making sure you have an extension of time clause, making sure you have a responsibility of them to respond to you within a certain period of time. So if you're building a website, for instance, or doing SEO services or doing something where you need information from your customer, you want to be making sure that you have a clause that says your customer is going to respond to you within a certain period of time. And if they don't, you get an extension of time. I do a lot in the construction industry, and construction industry is very similar to the intellectual property area or space. As a builder, you build. You first build your base, your slab, your concrete slab. You then build your frame. You then put the windows in. You get the lock up. You then fit it all out by putting the basins in and the plywood in, and then you reach your fixed stage, and then you got your completion. Now in IP, which a lot of the people who are listening today are in services in terms of software development, website development, SEO, things like that, you're in the same boat. You have a scope of works, you deliver your first set of scope of work, so you get paid upon the delivery of that first set. You then do the next set, you get paid then, and you get paid then, and you get paid then. What's really important right now is you are getting a deposit, or you're getting money paid in advance for those stages, or you make sure you stop your services until your invoice is paid, and you break down your services into chunks, similar to building a house. When you build the house, you lay your concrete, you get paid. You put the frame up, you get paid. You put the windows and doors in, you get paid. And you got to break down your services just like that to make sure you're getting paid, because right now is a very volatile situation, and your long-term customers who you've been dealing with for a long, long time, who you think have the financial capacity to pay you, they might not. So to minimize the guarantees, you need to communicate. You need to find out whether your suppliers are going to be delayed. You need to make sure that your supply chain generally is still competent to deliver. You need to, if you're outsourcing anyone, you got to check up on them. You got to get them to send you an email. Make sure that they can comply with certain clauses. Open up your agreements and say, just checking, you've said that you promise that you're going to have enough people to do this. You promise that you're going to be able to do this and this, just making sure we're still on the same page. Are you still able to fulfill your obligations here, to make sure that if they were to breach, then you in turn breach? You need to know whether they're going to breach, because that would end up resulting in you breaching. So communication is key. Same thing with customers. If you find there is going to be a delay, you need to then go and advise your clients of it. And if you have clauses, again, extension of times. Picking up the phone is probably better than putting in an email, but pick up the phone and then put it in an email afterwards. You want evidence in writing showing that you've dealt with certain issues in advance, because you're mitigating their loss. Whenever a customer wants to sue somebody for breach of Australian consumer law guarantee or breach a term of a contract, they have a duty to mitigate their loss. What that means is they can't sit on their hands and say, oh, I lost everything. Now I'm owed all this money. Oh, I was supposed to be delivered this website on the 1st of May. they never delivered it, so it's now September and I've lost all this money. No. They have an obligation to go and find someone else, build a new website, get it up and running, and pay them. And then between the 1st of May to when their actual new website was launched, they might have damages within that period. But they have to mitigate their loss. You have to mitigate your loss. Your supplier has to mitigate their loss. Your customer has to mitigate their loss. Everybody has to take appropriate steps to minimize your risk. And hopefully everybody just works together and understands each other. And hopefully everybody just works together, which I trust most people will be doing. Now, in terms of refunds and replacements, if you don't have replacement parts for certain things, or if you don't have spare parts, then you might be wanting to tell your customers, we don't have replacement parts, but we're doing we don't have replacement parts, but we're doing full replacements. This is our new refund policy. That refund policy is now saying, if you haven't opened it, take a picture of it. You pay for the delivery back. We pay for the delivery of a new good, whatever it might be. Your refund policy is only for 30 days. You don't offer refunds. You only offer credits. Whatever it might be, you need to start tailoring refund and credit policies moving forward for all your new customers. So let's talk about managing cash flow. There's certain things that you need to consider, because now is not only a lot of businesses going to be slowing down, a lot of businesses are also running out of money, and they're only going to be paying for essential services. And if they're only paying for essential services, you might not be essential. I once had a client, I went to their office, and there was like a wheel of fortune on their table. And I looked at it, and my law firm's name was on that wheel of fortune. And they spun it. And I said, what's that? And they said, well, that's who we decide gets paid. And they said, good thing you're on it, because some of our creditors aren't even on it. So that's the reality right now. Some people are going to get paid. Basically, the greasy wheel will get the oil, or the squeaky wheel will get the oil. And if you're not essential, they might not be paying you. Essential right now are paying staff, making sure your rent's paid, making sure your invoices for telephones, internet, these are all essential services. You're not. And they've recently changed the law to make it more difficult to recover money from your customers. And I'll get into that in a moment. So projections, cash flow forecasting, contact your accountant. There's a lot of different templates on the internet that deal with cash flow, projections, forecasting. You can, I believe the banks, I think many years ago, I grabbed one off of the ANZ website. There's a lot of different packages available for small business to help them prepare with cash flow, projections, and forecasting. And make sure you start putting all your expenses in now, and make sure you draw a line in the sand. You say, these are our targets for this month. These are our target sales for next month. If our targets fall below this amount, we've got to consider retrenching staff, unfortunately, because we need to maintain a positive cash flow. Know what the trigger is when you need to start reducing your costs. Consider whether you need to raise money now, whether it's from mom and dad, whether it's from your friends and family, whether it's from the banks, whether it's from government incentives. You need to consider whether you're going to need funding, and you only know that if you do your proper projections. In law, we have phrases called BATNA, and BATNA means your best case scenario. And then you have WATNA, which is your worst case scenario. So your projections should have both. And if you hit your worst case scenario, you need to know what you need to do to get those funds in quickly. You can get loan facilities. Loan facilities basically say, we will give you $100,000, and you get that approved, and that's guaranteed, but you don't have to call upon it until you need it. So you can look into, and you don't have to call the whole 100,000. Maybe you call 20,000 at the end of the month. Maybe you call 50,000 later. You might want to look into lining up some facilities and signed that are guaranteeing you money if the worst case scenario happens, and being able to call on somebody for that support. And in terms of raising funds, it can be by way of issuing shares and they become a shareholder. It can be by way of a secured loan. It can be way of a SAFE, which is called a simple agreement for future equity. That is saying, I actually don't know what the value of my shares are right now, but I'll take your money now. And when we go and raise money from someone else, you'll convert into shares at that time at a discount of 80%, for instance. Look into whether there's R&D funding. R&D funding, there's a lot of different companies out there that will help you maximize your R&D incentives at the time when you have to put in your applications. Like for instance, there's one called FundSquire. I'm not promoting them, but basically they say, okay, I can see what you're developing now. You need another $100,000 to develop that technology. And once you develop that technology, you'll then be able to get it to market. But you don't have that $100,000 to finish the technology, so we'll lend you that $100,000 right now. You can then start working on your R&D. You'll then put in an R&D grant, and the government will give you back the money that you put towards it, and they get paid back first. So have a look at that. There's lots of different parties out there that offer that R&D funding. There's also line of credits, credit cards, private funding. You got to be very careful for, well, it's insolvent trading. If you as a director sign off on a loan, which you know you cannot pay back, you can be personally liable for that loan, because upon the signing of that loan, when you knew you could never actually repay it back, you committed an act of insolvency. And a director is personally liable for insolvent trading, subject to the COVID-19 changes in laws, which deals with insolvent trading, and it gives some relief to small companies in those situations. So just be careful about private funding and your personal liability. There's tax state extensions you can get. There's a lot of different initiatives from the federal government. Collecting debts. Now, in terms of undisputed debts, you can normally issue what's called a stat demand. You delivered a good, they received the good, they owe you the money. Before, you could issue what's called a statutory demand, and it basically says, you owe a debt that's undisputed, you must pay it in 21 days. If you do not pay it back in 21 days, then I can go and seek an order from the court to wind up the company and point a liquidator in and sell all the assets and pay myself back. Before, that debt only needed to be $2,000 and the period of time to respond was 21 days. Now the amount of the debt must be $20,000 and the period of time to respond is 60 days. That means it doesn't actually give a lot of leverage for you to collect an undisputed debt. So going back to what I said, make sure you get money paid in advance. Make sure you split up your services into separate stages and get paid as you complete those stages. And if there's a delay on the invoices, suspend your works, because collecting debts now are not that easy. The next one is disputed debts. If it's a disputed debt, if you issue illegal proceedings today, you might not get a hearing until next year. So if you do have debts and you want to get paid, you're better off just issuing those proceedings now so they start in the process, so that you're the first in line to get paid, because there will eventually be a hearing, and that hearing will be before everybody else's, and you'll be able to enforce your judgment before everybody else comes in later. Take personal guarantees if you can. If you're doing business with another company, try to get a director guarantee. I've issued a new policy in my firm. We take everything up front. We have a trust account though, so we can. But even for long-term existing very good clients, that's what we're doing. Make sure, a lot of people have 45, 60-day payment terms. I don't know why. Big big companies like VisiBoard, and they have 60-day terms. That's because they have the bargaining position to pay you in 60 days. They get paid a lot earlier. There's no reason to have an invoice that says for you to get paid in 45, 60 days. A lot of people have it 30 days, but there's nothing saying it can't be 7 or 14 days. So consider changing your payment terms to a shorter period of time, because when you issue an invoice and it's 30-day terms, you'll keep on working. You won't know for 30 days whether your client's going to pay you or not. If you change it to 7 days or 14 days, you'll know right away whether they're going to pay you or not. So consider changing your payment terms. Take money in advance. Consider getting a personal guarantee. If you have a lawyer, or if you're looking for a lawyer, lawyers have trust accounts. They can ask for money to be paid in advance. And those are just some of the things to manage your cash flow. There's different insurance policies, such as business interruption insurance. If you have it, look at it. I can't guarantee it's going to cover this current situation. I've already got into the statutory demand changes. You also have the bankruptcy proceeding changes as well. So just have a look at that. Commercial leases, everybody has issues with this right now, and I cannot give a lot of guidance because we're waiting to see what the government says. Having said that, high level general provisions that are in most commercial leases, you have a right to quiet enjoyment. So if your building gets locked out and it's no fault of yours, it's likely that the landlord has breached their duty to give you a possession and quiet enjoyment. So if your building's locked out and the government has made a declaration that building's locked out, there will be a good chance that your landlord has now breached its terms of the lease by not giving you possession and not giving you quiet enjoyment, which may give you an out. You also have a right to the amenities of the building, the elevators, the bathrooms, the whatever else it might be. If you don't have those amenities, there might be an out as well. Frustration. If your building is locked and you can't get into your commercial office, it is likely your lease agreement will be frustrated. Frustration, the best way to give you an example of it is there's a case up in Queensland for many years ago where a wedding party or a bride and groom had bought a venue for their wedding. The place burnt down. That was frustrated. It cannot be done. You cannot have a wedding at that venue because it doesn't exist anymore. You cannot lease out a premise if your building is locked out. So it's frustrated. And force majeure, which is another out, which is an act of God, floods, strikes. You may have a clause dealing with pandemics. Most people didn't foresee a pandemic, though, other than Donald Trump. He definitely predicted that, and he knew better. Anyway, so what can you do? You can look at rent abatement. You can communicate. Everything's about communication. Communicate with your landlord. Say, look, we're about to have some troubles. You have two options here. You can continue forcing us to pay the entire amount, and we'll terminate it, our lease, and you can try to recover from us. Good luck. And good luck finding another tenant anytime in the next year, because all the commercial leases around here are going to be terminated, and there'll be so much vacancy that you'll never see another tenant. So you can either accept a lesser rent now and keep us here and cover your mortgage, or you can kick us out and get nothing. Which option do you want? If your amenities or if your quiet enjoyment is resulting in a reduction of your office, you can actually make an application to QCAT, NCAT, VCAT, or whatever tribunal or court in your territory, state applies to get an actual rent abatement. They can make a court order saying, well, you're not getting what you were promised, so we consider you're not getting around 20% of what you promised, and therefore we're going to reduce your rent by way of court order by 20% until it goes back to what you were promised. And then have a look at the government updates, because they're coming very soon in dealing with this. It's a chain reaction. The banks expect payment from the landlords expect payments from the renters or the tenants. So the landlords will press for rent because the banks are pressing them. If the bank stopped pressing them, they should stop pressing you. There's a bunch of different incentives out there. I think everybody would have got hundreds of emails like I have on all those incentives. Most of them are dealing with accounting issues. So because I've now been talking for an hour, I think it's more important to get into questions. In these slides, they set out all the different incentives that are out there at the moment. So I'm going to bring Tom in, and Tom will go over some of your questions, and I'll try to do a question and answer period now.
Just all from here. So maybe if you just want to check.
All right, so Natasha says, if you run a service business and then your work days dry up as a result of COVID-19, can you stand staff down? The answer is yes. As I mentioned, the awards have specific stand down provisions. If you're covered by the award, if you're in retail, hospitality, etc. So the awards deal with stand down, forced stand down. If you're not under an award, then you can consult with your staff, give them the options of taking annual leave, give them the options of taking unpaid leave. If they don't agree with those options, you can make them redundant. Can you ask employee to take annual leave during COVID-19? Yes, we've answered that. Adam says, we have had to stand down all 10 staff and our incoming work has dropped by 95%. We have stood down with the intention and plan to rehire them if work comes back. Paying out owed annual leave in lump sum is a plan, and this seems to be preferred way. Are we doing things the right way? So if you do make someone redundant, so this is a typical redundancy, there's two things that you're going to have to pay. One is notice, and one is redundancy pay if you're not a small employer or if the modern award says you have to pay redundancy. So if you make someone redundant, you have to, one, give notice in section, and the notice period is in section 117 of the Fair Work Act. And you either give them notice and they continue on working during that notice period and then their employment comes to an end, or you give pay in lieu of notice and you say, you know what, there is no work, I'm just going to pay you out, here's your notice period. You have an obligation to give that notice. You have an obligation to seek other jobs that might be available. And if there's no other jobs that are available, and if you've given that notice and you've consulted with them and talked about the options, then you can make them redundant, and that's the right way. Again, some people are afraid to make people redundant. If you do make people redundant, it will definitely have effects on how much you receive from your government incentives, because the government incentives right now are based on the withholding the pay as you go withholding. And so if you don't have any staff or withholding anything, you'll get less government grants. So the government has put in initiatives to try to essentially reduce wages for the employer. So you want to probably talk to your accountant to make sure you're making the right decision. But also remember, making someone redundant might be the right decision as well for the employee, because they will be able to get on to a New Start benefit. They will be able to get the benefits offered by the government. And I believe there's also rental assistance. If it's not already approved, it's coming. So although people are afraid to make their staff redundant, the reality is if there's no work, rather than telling them to take unpaid leave, you might be better off actually making them redundant. So Louise says, I have permanent staff and they're under the Clerk's Private Sector Award, if they can work from home, but we can no longer afford their services, what are our options? There's something called constructive dismissal, and it's basically where an employer changes the terms and conditions of the employment. So for instance, you could go to an employee and you could say, I can't keep you for 5 days a week. I can't keep you for 5 days a week because our turnover is reduced so much. But I can keep you on 3 days a week. I'll give you two options. One, you can accept the reduced rate or the reduced days, or two, I have no choice but to make you redundant. And that's an ultimatum that you're allowed to do. Under the Clerk's Private Sector Award, you must consult under Section 8. You must consider Section 34 as well, which means sending them a letter telling why there's a change. There's going to be guidance under change of hours as well. So have a look at those. You can give your employees an option to reduce their hours. Has to be by agreement in writing. Cheryl says, if employees feel at risk working in the office, do the underlying health issues basically require them to allow them to work from home, and can the employer force them to work in the office? I can't give you a 100% guaranteed answer on that. Under the occupational health and safety, you have an obligation to provide a safe workplace. If you are not providing a safe workplace and they get sick as a result of you not providing that safe workplace, you're opening yourself up to a work cover claim. And you're also opening yourself up to a breach of the occupational health and safety regulations. And OH&S regulations in most states now make it a personal liability on the managers of the OHS or the directors of the company, and there's hefty fines. So as long as you think you have a safe working environment, then you should be okay. As long as you follow the government's protocols, you should be fine as well. My concern mostly is, even if your office is safe, is it safe for your staff to commute via public transport? I don't know. The answer is look to the government, follow the government policies. As long as you have implemented and followed the government policies, it'd be very difficult for anyone to come after you for breach of the OH&S provisions. Cesar says, as a not-for-profit, we have some reserves in the bank due to the profit from several years. After we pay suppliers, we can use that money to keep the company afloat? As a director of a company limited by guarantee or an incorporated association or whatever it might be, a director has a duty to use due skill and diligence, best interest of the shareholders. In a personal guarantee or in a company limited by guarantee, it's not in the best interest of the shareholders, because there are no shareholders, but you have to act in the best interest of your members. So if you are keeping it afloat simply to keep your job, that's probably not the right way to be using the funds. It might be better to put your company into standstill temporarily and not spend that money. But obviously it depends on your current circumstance. If you're actually providing the services that your not-for-profit is providing, and from a reasonable person, it makes sense to keep it afloat, then you can probably use that money. But if you believe that you're really just blowing that money without any justified reason, then I would consider what your options are to basically put your company into a standstill. And will it be seen as insolvent trading? The definition of insolvent trading is I can no longer pay my debts as they come due. So as long as you can pay your debts as they come due, you're not insolvent trading. Alex says, if an employee comes to you and says, I want to work from home, however, the CEO says you need to keep commuting in until the government says you're not allowed to, i.e. coming to the office to work, is there any liability on the employer? My answer is always going to be follow what the government says. The government is implementing systems. The government has said, if you watched Scott Morrison last night, he essentially said, if you can work from home, work from home. If there's actually an ability to work from home, work from home. If you cannot, and it results in a significant reduction of your staff's ability to work, then you can bring them into work and you can tell them to come into work. But if you come into work, make sure you're following the government policy. There's a debate on whether Uber and taxis are safer than public transport. Because if you're in an Uber or taxi, it's just one person that you're dealing with and you can sit in the back seat, have a mask on with your head out the window. Whereas commuting, you're swiping your card, you're holding on the railing, whatever it might be. If your employee does not want to come in, you might want to consider opening up a cab charge account or an Uber account to give some relief to that staff. And it's an expense on the company, but there's some good discounts on Uber at the moment, so maybe that might give some relief. Can we ask proof of hardship from tenants before granting relief? Absolutely. If a tenant and you're a landlord and a tenant says, I want a reduction on my lease because my business is failing, certainly you should ask for evidence of that. There will, unfortunately, be a lot of people who try to take advantage of things when they shouldn't be. And so you should really consider. If you look at the banks have hardship provisions in all their lending documentation. If it's a national credit code loan, if it's a domestic purpose loan, and they can stop all loans for up to 6 months on grounds of hardship. You can randomly go and grab a hardship application from any government or any bank website and have a look at what questions they're asking for proof of hardship. And then you can replicate that and use those questions that the banks are using. I'm not promoting copyright infringement, but you can maybe use that as a guidance, or you can look at the legislation which deals with hardship applications. But certainly I would consider asking for evidence. It's not a guarantee that COVID has resulted in the company reducing their sales. Some companies are doing better than ever. Alex talks about hiring contractors and if there's no work, whether there's a requirement to give them notice. First question is, do you have a contract with that contractor? If you do, you got to follow the notice period. Most contractors' agreements give 1 month notice. So what that means is that you have to look at your termination clause, you have to look at your notice period clause, and again, communicate. If there's no work and there's no right for you to terminate the contract and there's no notice period, you're probably best off contacting a lawyer to get you out of that agreement, because it will be tricky, but there will be ways to get around it, likely. Liz says, what records and details should we be keeping to ensure we are able to prove loss of revenue for any future claims or government assistance? For example, we had events canceled. I keep emails received from clients advising of cancellations, but anything else? If you have an event and you have, let's say for instance, you have records and evidence of past events. A lot of times when you are suing in court and you have to prove a loss and you can't prove that loss because it never actually happened, there's normally a matrices on how to calculate that loss. And you normally get an accountant to do projected losses. And the way it normally works is you say, these are the past events we have held. These are how many attendees we have had. And this is the revenue we have earned. And this is what the profit after expenses that we've received per event. And that's in the last 6 months. You then use your historical data from this time last year, and you do the same thing, and you look at what that was. And then you will then get a forensic accountant or your accountant to do a calculation of your loss. And they'll look at what your revenue was. They'll look at what your profit was. They'll look at what your expenses were. They will then look at where you were at last year, and they'll be able to calculate a projected loss or an actual loss. Generally, the courts will automatically discount it by 20%, but that's how you would be calculating loss. It's normally based on historical data. If it's not on historical data, you'll have to use industry data, which you probably won't have. I'm talking about court scenario because in terms of government grants and so on, it'll be similar evidence. You also have to make sure you have proper policies in place and terms and conditions, because you can't just be refunding everybody for everything. If you have proper credit terms, you can give people credits potentially. But I had one of these the other week. Someone promised they're going to do an event on, let's say, today. They don't have any terms other than saying, we promise we're going to do the event today, and you pay this much for today's event. They've then canceled it, and they want everybody to go and do it another day in the future. They don't have any policy about changing that time. They don't have any terms and conditions about giving credits or refunds or anything. So you really have to go back to the fundamentals, which is Australian consumer law. There was an offer to do an event today. You promised to do the event today. They paid for the event today. You didn't deliver it today. Breach of contract. Go back to your guarantee, Australian consumer law. You promised it would be performed today. You didn't deliver your service in a reasonable period of time. You're in breach of the ACL. You can get around all that if you actually have proper terms. Can we include a sick leave? Can we include the sick leave together with the annual leave during the stand down? Yes, I believe so. I've definitely seen a lot of employers doing it. Sick leave does not get paid at the end of employment. So let's say Jane Smith has 10 days of sick leave and 10 days of annual leave. If you were to make Jane Smith redundant, you'd only have to pay out the annual leave. You would not have to pay the sick leave. So entitling an employee to get paid sick leave when they're not sick is actually taking away from the benefits of what the employer has, because it's a benefit the employee gets only if they're sick. So if the employer says that you're allowed to take your sick leave now, then that's actually a benefit to the employee that the employee might not otherwise get. But what you also might want to do is say, but if you are legitimately sick, that will be unpaid in the future. So you'll again want to get an agreement in writing. You can take sick leave, but if you're sick in the future, this is going to be unpaid. So that's just what my guidance would be. Hairdressing salon now cannot continue to trade as there's no service that can be done under a half an hour limit. My haircut takes about 7 minutes, but that's me. But if it's not me, then yes, I can assure you that I know a lot of my friends who probably take 2 hours. So you guys have decided temporary close. Can we stand down all the workforce under 524? Staff are all under salaried contracts. The reality is that 524 simply says reasonable, I believe, reasonable shutdown. don't have your award in front of me, but in essence, you need to consult. Clause 8, you got to explain that your customers cannot get a haircut done in 30 minutes, and therefore we cannot stay open. You then have to give them the option under section 34, which is award, or which is annual leave. Allow them to take their annual leave. And then you can implement the shutdown, yes. Because the shutdown has to be reasonable. That's the terms of legislation, reasonable. Your circumstance certainly sounds reasonable if there are no customers that can get their hair done in 30 minutes. Please clarify the rights of employer to require employees to take unpaid leave. I think I've touched upon that several times, but your best bet is just to simply look at an award, any award. You just go to the Fair Work Act, typed in hospitality, section 34. That gives a lot of guidance. Even if your employee is not on an award, it gives you guidance of circumstances where you can take unpaid leave. Unpaid leave, again, it's a benefit to the employee to keep their job. It's not necessarily a benefit to the employer, because you're allowing them to keep their job, and while they're on unpaid leave, they continue to accrue their annual leave. So even though you're not paying them during that period, they're actually costing you money because they're accruing annual leave during unpaid leave. But again, going back to what I was saying at the beginning, consider whether unpaid leave is the right option for your employees. Let them know that, you know, if they take unpaid leave, then there is a circumstance where they might not get the benefits that the government is offering. Daniel says, do we legally need to consider a COVID policy for the business, remote working from home meetings, what should happen if they're infected during the engagement, so on? We still have staff working with essential service clients who have their own policies on COVID, working from home, blah, blah, blah. I was trying to explain this to one of my clients before. It seems very far removed and far-fetched, but as an employer, your employees are covered by work cover or work safe policies. When you have an employee who is working in your business and they get injured, whether they're going to work or coming back from work or at work, your work cover kicks in and covers for that injury. When they're at home now, work cover should be covering them while at work. But if you do not have a policy and your employee plugs in 25 different things into one plug and burns down the house, the question is, well, who's responsible for that? Who's responsible of making sure that your employee is acting reasonably and not negligently in operating out of their home? Certainly, public liability insurance perspective, as a insurer for a home, as the insurer, I would be saying, well, that's not my fault. That was your staff who were under your control who did that. And therefore, because they did that, we're not covering it under insurance. So say goodbye to the home. We're not covering it. That's the employer's responsibility. I don't see any reason why you don't implement a policy. It's pretty easy. Go to Lawpath. You probably already have an account or a username and password because you're attending this webinar. You can download a free policy from a work from home policy from their website. It's very easy. I think the only clause that I would really change is that they have the application. Employees can apply, and there's a whole long process of applying. You can probably just change that clause to say everybody's eligible if you give us notice in writing or something like that. Tone it down a little bit. But I reckon you should put one in definitely to protect yourself from an OH&S perspective, to protect yourself from an insurance perspective. Can we request full-time employees to go 4 days temporarily without giving an ultimatum between that option and redundancy. So can we ask them to go from 5 days or 5 days to 4 days? If you're changing your employment contract. So if you're actually changing your employment contract and you were to just simply force them to do that, they can resign and sue you for unfair dismissal, because that's something called constructive dismissal. You have literally changed the contract, changed their conditions of employment, now paying them less, and therefore you now open yourself up to an unfair dismissal claim. If you're going to change them from 3 days to 4 days, or from 5 days to 4 days, you need to consult with them and get an agreement in place. I agree that I will change my hours of operation from 5 days to 4 days for the next 4 weeks until otherwise reviewed. And that means that their annual leave and everything else. But get it in writing, put a start date, put an end date, make sure the employee is aware of their rights, send them the Fair Work statements. Fair Work has a great page on COVID right now. Go to theirs. They have a lot of answers that can be questions are being answered. Lawpath has a ton of articles being pumped out at the moment. Go to there. They can direct you to a lot of different places as well. There's a lot of free information. But I would get an agreement from your employee to go from 5 days to 4 days, not force them to do it. So your ultimatum is you do go down to 4 days. Well, first ask, do you agree to go to 4 days? If they say no, then you say, well, I'm sorry, there's no job available for 5 days because we've just lost this much revenue. We don't have the financial capacity to pay. And because we don't have the financial capacity to pay, we have no other option but to make you redundant. But we are now looking for other redeployment positions available in our company. Hey, we have a 4-day job that's now available. Are you interested in being redeployed into our 4-day position? And if they say, no, we're not interested in your 4-day position, then you say, okay, well, that's fine. Then you're going to be made redundant. One, the employee didn't mitigate their risk. They had you followed your obligations pursuant to the redundancy. You consulted, you gave them a redeployment option. You told them that their job was going to be made redundant, but there was another position available for 4 days. They rejected it. You make them redundant. You'll probably be okay in terms of an unfair dismissal claim. I say that obviously subject to legal advice, as you probably know. Can we force staff to take long service leave now? Yes, you can reach an agreement on taking long service leave. Every state is different. Long service leave, unlike pretty much everything else, is a state-based legislation. And so you'll have to have a look at the Long Service Leave Act in your state and see whether there's an ability for that. High level on long service leave, if your employee has been employed for 10 years, they are then entitled to their long service leave entitlements in New South Wales. Victoria and every other state's different, so I'll just say that. And then if you were to terminate your employee or make them redundant whilst they've been employed between the 5-year mark and the 10-year mark, then the employer must pay out the long service leave on a pro rata basis. And if the employee resigns between the 5-year mark and the 10-year mark, you don't have to pay out your long service leave, their entitlements. And then if the employee is from 0 to 5 years, you don't have to pay any long service leave on redundancy or termination. So post that trigger point, which is 5 years in New South Wales, if they resign, they don't get any long service leave. If they're made redundant or terminated, they get paid out their long service leave. I believe Victoria and Queensland are both, instead of 5 years, it's 7 years. But you'll have to double check. Please clarify how employees accrue entitlements while on unpaid leave. While on paid leave, it's going to be based on their employment contract. Their employment contract is Monday to Friday, 9 to 5. Their annual leave continues to accrue. Don't ask me. I didn't make the law. I don't know why that is, but that's what the legislation says, strangely. So if you were to not want to pay them their annual leave entitlements, what you would do is before they took unpaid leave, you would say, you agree that we are reducing your hours of work to 0. And whilst you're reducing your hours of work to 0, you will continue to work for the next X period of time, and you will receive an ability to be paid unpaid leave. If you were to do that, then you probably wouldn't accrue annual leave because you've, by written agreement, amended your employment contract temporarily so that there's no actual annual leave that would be accruing. Do you have any further info on your comment about the relaxation of responsible lending guidelines? I'll ask Lawpath to see whether they have any information, and yeah, I'll have them either contact you directly or provide you with some sources if they have them. I do see that there's some comments in there, so maybe hopefully that's being addressed. Will working from home create a future GST liability for sale of a principal place of residence? I do not give tax advice verbally under any circumstance. I'm sorry. Every situation is totally different. So I won't provide any advice on that at all, on the, capital gains tax liability. Is there any other final questions? Any questions that I missed that anyone wants me to ask or answer, sorry? All right, well, that's it. Thank you very much. If you need any more information, you can visit accounting websites, you can visit Lawpath website, you can visit government websites, stay up to date on the news. If you're looking for a lawyer to help you, Lawpath has over 1,000 lawyers on their platform that are all available. They're all working from home mostly. They are probably the best placed law firm in this country that I can think of, because Lawpath is a technology company that deals with remote lawyers already. So there's no hiccups, there's no delay, and Lawpath can certainly assist. And will our slides be made available, Lawpath? Yes, they will. All right, well, thank you very much. And that is the end of this seminar. We may have another one later on commercial leases if we get any government guidance. So thank you, and stay safe. And if you have any questions, let me know.